Imagine this. It's 9:45 p.m. You're driving home from the range, or maybe just coming back from a late dinner. You see the blue lights in your rear view. Your heart does that familiar thud against your ribs. You aren't a criminal. You've got a clean record. You've got your concealed carry permit right there in your wallet. You pull over, hands at 10 and 2, interior lights on, doing everything by the book. The officer walks up, shines that high lumen tactical light into your eyes, and asks the question that could determine the next 10 years of your life. Do you have any weapons in the vehicle? In that split second, your brain is screaming at you to be the good guy. You want to prove you're law-abiding. You want to show you have nothing to hide. But here's the terrifying reality I see every single day as a defense attorney. 90% of gun owners talk themselves straight into a felony charge in the next 30 seconds. They say too much. They volunteer details nobody asked for. They walk into legal landmines they didn't even know existed. What you say in the next 10 seconds could be the difference between driving away with a warning or being dragged out of your car in handcuffs. And here's what keeps me up at night. Almost every gun owner I've represented got this wrong. Every single one. Before we go any further, do me a favor. Hit that subscribe button right now. I mean it. Because what I'm about to reveal could save you from a weapons charge that destroys your Second Amendment rights forever. And statistically, only 15% of people watching this video are actually subscribed. That means 85% of you are one click away from missing the legal strategy that could save your freedom. Don't be part of that statistic. Click subscribe, and let's make sure you're protected. So what are these 5 words that could keep you out of jail? I'll tell you in just a few minutes. But first, you need to understand something that most gun owners never learn until it's too late. Every single week, I get a phone call that starts the same way. I was just trying to be honest with the officer. I thought if I told the truth, everything would be fine. And then I have to explain to them why their honesty just cost them $15,000 in legal fees and potentially years of their life. See? Here's what happens during a routine traffic stop. You're sitting there, adrenaline pumping, officer standing at your window, and your brain is screaming at you to be respectful, to be cooperative, to show them you're one of the good guys. So when they ask about weapons, you start talking. Yes, officer, I have a Glock 19 in my center console. I have my concealed carry permit right here. It's loaded, but the safety's on. Well, actually, Glocks don't have a manual safety, but what I mean is my finger's not on the trigger. I was just at the range. I'm not a criminal or anything. I'm a responsible gun owner. I voted for the sheriff. My brother-in-law is actually a cop in the next county over. Sound familiar? Here's the problem. You just gave that officer approximately 15 different pieces of information they never asked for. And every single sentence you added just created another potential legal trap. Let me tell you about a real client of mine. We'll call him Jim. Jim was a veteran, a father of 2, and a permit holder. He got pulled over for a simple lane change violation. Nothing major, a warning at most. When the officer asked about weapons, Jim decided to be transparent. He said, "Yes, sir, I have my Glock 19 in the center console. It's loaded, and I have my permit right here." Sounds like a perfect interaction, right? Wrong. The officer asked, "Is it loaded?" Jim said yes. The officer asked, "Why do you need a round in the chamber?" And now Jim is trying to explain his personal defense philosophy to a cop who's already decided he's looking at a gun nut. Jim starts talking about stopping power, personal protection, constitutional rights on the side of the road. The officer interpreted Jim's explanation as aggressive. His tone shifted. Backup got called. Jim ended up face down on the pavement with a knee in his back. His car got searched. They found nothing illegal, but now Jim is traumatized, and he's paying me $8,000 to clean up a situation that never had to happen. All because he answered questions he had zero legal obligation to answer. Maybe you said the gun is in your console, but it's actually technically within reach, which in some jurisdictions means it's on your person even without a permit that covers that. Maybe you said it's loaded, but you forgot your state has weird transportation laws about ammunition and firearms. Maybe your permit is valid, but you crossed a county line where reciprocity doesn't apply. This is why I've built my entire practice around defending gun owners. Because the legal system is a minefield, and most people are walking through it blindfolded. Let me paint you a picture of how fast this can go wrong. You're driving home from work. Your legally owned firearm is in your glove box. You get pulled over because your license plate light is out. That's it. A $30 fix-it ticket. The officer asks if you have weapons. You, being honest, say yes. You explain where it is. The officer asks you to step out. During the pat-down, they find a pocket knife you forgot about. Now you've got multiple weapons. The officer asks if there's anything else. In your nervousness, you say no, forgetting about the baseball bat in your trunk from last weekend's game. They search your car. They find the bat. Now you've lied to a police officer about weapons in the vehicle. What started as a burned-out light bulb is now obstruction, providing false information, and depending on your local prosecutor's mood, potentially unlawful carrying. Your $30 ticket just became a $20,000 legal nightmare. And it all started because you answered one question you didn't have to answer. Here's what they don't teach you in your concealed carry class. When an officer asks if you have weapons, they're not making small talk. They're conducting what's called a Terry inquiry. This comes from a 1968 Supreme Court case, Terry versus Ohio. Basically, if an officer has reasonable suspicion that you might be armed and dangerous, they can conduct a limited pat-down for weapons. Notice those two words, armed and dangerous. Having a legal firearm doesn't make you dangerous. But here's the catch most people miss. The moment you tell an officer you have a weapon, you've just confirmed the armed part for them. Now they get to make a subjective determination about the dangerous part based on your behavior, your words, your tone, even your appearance. And that's where everything can spiral. But wait, you're thinking, don't some states require me to tell the officer I'm carrying? Great question, and this is where it gets complicated. Roughly 12 states have what's called duty to inform laws. Places like Ohio, Michigan, Texas, Louisiana, North Carolina. In these states, you're legally required to immediately notify an officer that you're carrying during a traffic stop. But here's what nobody tells you. Even in duty to inform states, there's a right way and a wrong way to inform. And in the other 38 states, you have absolutely zero legal obligation to volunteer that information. None. Yet most gun owners don't even know which category their state falls into. They just assume they have to tell, so they start talking. And that's exactly where prosecutors love to build their cases. If this is making you nervous, good. It should. Because knowledge is the only thing standing between you and a criminal record. Subscribe right now because I'm constantly updating this community on the legal changes happening in your state. The next video I'm dropping breaks down the 3 questions police ask that sound innocent but are actually evidence-gathering tactics. You need to see that one before your next traffic stop. And only the 15% of this community who are subscribed will get that notification. Don't be in the 85% who finds out about the law after the handcuffs are on. All right, we're at the moment you've been waiting for. When a police officer asks, "Do you have any weapons in the vehicle?" Here's exactly what you say. Are you ready? Here are the 5 words. I don't answer questions. That's it. 5 words. Simple, direct, legal, respectful. Now, before you freak out and think this sounds confrontational or rude, let me explain why this is actually the safest response for everyone involved, including the officer. First, you're not being disrespectful. You're not saying none of your business or I plead the fifth in some aggressive tone. You're simply exercising your constitutional right to remain silent. The Supreme Court has repeatedly held that you have the right not to answer questions during a police encounter. This is basic Fifth Amendment law. Second, you're not lying. This is huge. If you say no when you actually have a firearm, you've just committed a crime in many jurisdictions. If you say yes and start explaining, you're opening a can of worms you can't close. But if you don't answer questions, you haven't lied about anything. You've simply declined to provide information, which is your absolute right. Third, you're protecting yourself from self-incrimination. Every single word out of your mouth is potential evidence. Every detail you volunteer can be twisted, misinterpreted, or used to build a case against you. By saying these 5 words, you're drawing a clear legal boundary. You're creating a legal stop sign. Here's where most people panic. They think, if I say that, won't the officer get suspicious? Maybe. But here's what you need to understand. Suspicion is not probable cause. An officer can't arrest you just because you exercised your rights. They need actual evidence of a crime. Let me walk you through what typically happens after you say those 5 words. The officer might respond, "Sir, I'm just trying to make sure we're both safe here." That's a fair concern. Here's exactly how you respond. You keep your hands visible at 10 and 2 on the steering wheel. You stay calm. You look at the officer and say, "I understand, officer, I don't answer questions." And then you stop talking. You don't fidget, you don't keep explaining, you just wait. The officer might try a different tactic. Are you refusing to cooperate? This is a psychological technique designed to make you feel like you're doing something wrong. This is the cooperation trap. They want you to feel like a bad guy for exercising a constitutional right. But here's the truth. Exercising your Fifth Amendment right is not refusing to cooperate. You respond, "I'm cooperating fully, officer. I'm just not answering questions." See the difference? You're being compliant with lawful orders. You're keeping your hands visible. You're being respectful. You're just not volunteering information that could incriminate you. In most cases, the officer will simply run your license, write your ticket or warning, and you'll be on your way. Why? Because most traffic stops are routine. The officer isn't trying to build a federal case against you. They're just doing their job. But what if you're in a duty to inform state? Great question. This is where the strategy shifts slightly. If your state legally requires you to inform an officer that you're carrying, you need to comply with that law. Failure to inform in a duty to inform state is itself a crime. But here's the key that most people miss. You inform them of the minimum required by law. and then you stop talking. In most duty to inform states, the law says you must notify the officer that you have a concealed carry permit and that you're currently armed. It does not require you to answer follow-up questions. Here's what that looks like in practice. The officer approaches your window. Before they even ask anything, you hand them your driver's license, registration, and concealed carry permit together. You say, "Officer, I'm required to inform you that I have a valid concealed carry permit and I'm currently armed." Then you stop. You put your hands back on the steering wheel at 10 and 2. You wait for instructions. If the officer asks, "Where is the firearm?" you can respond, "I'd prefer not to answer questions, but I'll follow your instructions for everyone's safety." See what we did there? You acknowledged their safety concern. You offered to comply with instructions. But you didn't volunteer the location, which could lead to more questions like, "Is it loaded? How many rounds? Do you have other weapons? Why are you carrying today?" Each of those questions is another opportunity for you to say something that could be used against you. This might be the most important legal information you hear all year. Don't risk missing updates like this. Laws change every single legislative session. I spend hours every week tracking these changes so you don't have to. Subscribe now so you're always protected. The next video covers what to do if they ask to search your vehicle, and trust me, you need to know that before it happens. Let me give you another example that shows why this approach matters. I represented a client in a duty to inform state. He got pulled over for rolling through a stop sign. He informed the officer he had a permit and was carrying just like the law required. The officer asked where the gun was. My client said, "In my waistband." Officer asks, "Is it loaded?" Client says, "Yes." Officer asks, "Why do you have a round in the chamber?" Now my client is explaining his defensive carry philosophy on the side of the road. He starts talking about stopping power, personal protection, constitutional rights. The officer interprets this as my client being paranoid or potentially aggressive. The situation escalates. More units arrive. My client ends up detained for 45 minutes while they run his information through every database they have. He wasn't charged with anything, but he missed his daughter's birthday dinner and spent the next 6 months having anxiety every time he saw a police car. It didn't have to go that way. If he had informed as required, then politely declined to answer additional questions, the entire encounter would have lasted 3 minutes. Here's what most gun owners get wrong about police encounters. They think the goal is to make the officer like them or trust them, so they over-explain. They try to justify their choices. They volunteer their life story. But here's the truth. The goal of a police encounter is to get through it safely and legally, period. You don't need to be best friends with the officer. You don't need to prove you're one of the good guys. You just need to exercise your rights, follow lawful orders, and protect yourself legally. Sometimes the danger isn't the aggressive officer, it's the friendly one. The officer who says, "Hey, nice Glock. Is that the Gen 5? I carry the same one. You got a round in the chamber or what?" This is rapport building. It's designed to make you lower your guard. The moment you start talking about stopping power or self-defense philosophy, you are creating a profile of yourself as someone who is looking for a fight. I've seen prosecutors play body camera footage of these friendly conversations to make a defendant look like a gun nut to a jury. Even if they're being nice, the 5 words remain the same. "I don't answer questions." Now let's address the elephant in the room. What if they search anyway? This is a common fear, and it's valid. Here's what you need to know. An officer needs one of 3 things to search your vehicle: your consent, probable cause, or a warrant. If they ask, "Can I search your vehicle?" you have every right to say, "I do not consent to searches." You say it calmly and clearly. If they search anyway, they'll need to justify it later in court based on probable cause. But by not consenting, you've preserved your Fourth Amendment rights. Your attorney can challenge the search later if it was unlawful. If the officer says they're going to search without asking, you don't physically resist. That's a crime. You simply say, "I do not consent to this search." Then you let them do what they're going to do. You document everything afterward. You get an attorney, but you don't give them a reason to add resisting arrest or obstruction charges. Here's what shocked me when I started practicing criminal defense. Most gun owners have no idea how many rights they're giving up during traffic stops. They think because they have nothing to hide, they should just answer everything honestly. But the criminal justice system doesn't work that way. Innocent people get charged with crimes every single day because they said the wrong thing at the wrong time. Prosecutors can take your words, twist them, and use them to build a case you never saw coming. That's not paranoia. That's how the system works. There's a saying among defense attorneys: you can't talk your way out of an arrest, but you can definitely talk your way into one. Every word you say is potential evidence. Every detail you volunteer is something that can be misremembered, misinterpreted, or weaponized against you later. The safest strategy is to say as little as possible while still being respectful and compliant. When you say, "I don't answer questions," your delivery matters just as much as the words. You're not aggressive. You're not smirking. You're not rolling your eyes. Your tone is calm, neutral, and respectful. Think of it like politely declining a sales pitch. You're not angry at the salesperson. You're just not interested. Same energy here. Your hands stay visible the entire time. If they're not on the wheel, they're on the dashboard where the officer can see them. You don't make sudden movements. You don't reach for anything unless the officer asks you to. And when you do, you narrate your actions. My registration is in the glove box. I'm going to reach for it now with my right hand. Is that okay? This level of communication shows respect for officer safety while still protecting your rights. Let's talk about the nightmare scenario. You used the 5 words. You didn't consent to the search, but the officer decides to arrest you anyway. Maybe they think your refusal to answer is obstruction, which it isn't. Or maybe they found something they think is illegal. This is the moment where most gun owners break. They think, if I just explain it now, I won't have to go to jail. They start pleading. They start bargaining. This is the most dangerous moment of your life. Once the handcuffs are on, the roadside interaction is over, and the criminal investigation has begun. If you are being arrested, you do 2 things. First, you comply physically. Don't give them a resisting arrest charge to tack on. Second, you upgrade your 5 words to the ultimate legal shield. I want my lawyer, and I am invoking my right to remain silent. From that moment on, you are a ghost. You don't talk about the weather, you don't talk about your family, and you definitely don't talk about your guns. Every word you say in the back of that patrol car is being recorded. Silence is your only friend until you see an attorney. Can you still end up arrested even if you do everything right? Yes, that's possible. Police can arrest you if they have probable cause, regardless of whether you answer questions. But here's the difference. If you stay silent, you haven't given them ammunition to use against you in court. Your attorney has a much better chance of getting charges dropped or winning at trial if you haven't made a bunch of statements that can be taken out of context. Every criminal defense lawyer will tell you the same thing. Cases are won or lost based on what the defendant said to police. Stay silent, and you dramatically increase your chances of a good outcome. There is a huge difference between being a constitutional auditor who screams at the police and being an informed citizen who knows their rights. The goal of this strategy is to be the most boring person that officer pulls over all day. If you are arrogant, if you are smug, or if you use the 5 words like a weapon, you are inviting the officer to find a reason to ruin your day. But if you are polite, if you say, I mean no disrespect, officer, but I don't answer questions, you are acting like a professional. You are showing that you understand the gravity of the situation. Think of it like this. A police officer is a professional at gathering evidence. You must be a professional at protecting it. By using these 5 words, you aren't fighting the police. You are participating in the legal system exactly the way the Founding Fathers intended. You are refusing to be a witness against yourself. At the end of the day, a concealed carry permit isn't just a piece of plastic. It's a massive legal responsibility. You have the right to carry a tool that can take a life, which means you have the obligation to understand the laws that protect your own. Here's what you need to remember. When an officer asks about weapons, those 5 words, I don't answer questions, are your shield. In duty to inform states, comply with the law. Inform them you have a permit and you're armed. Then stop talking. In non-duty to inform states, you have 0 obligation to volunteer information. Keep your hands visible, keep your tone respectful, keep your words minimal. If they ask to search, clearly state, I do not consent to searches. If anything goes wrong, invoke your right to remain silent and call an attorney before you say another word. Your checklist for every traffic stop. Hands at 10 and 2. Interior lights on if it's dark. Don't reach for anything until asked. Speak only when necessary. Be polite, be professional, but don't be a witness against yourself. The criminal justice system doesn't care if you're a good guy. It only cares about what can be proven in court. Don't give them the evidence they need to take your rights away. Stay silent, stay respectful, stay free. This has been educational information to help you understand your legal rights. It is not legal advice for your specific situation. Laws vary by state and circumstances vary by case. Always consult with a qualified criminal defense attorney in your jurisdiction before making legal decisions. This content is for informational purposes only.